Everyone.
Good morning, my lady.
Morning, my lady.
Morning, my lady.
Nelly Siwa, may you please place the matter on docket?
May it please the court, my lady. Morning.
Thank you, Judge. 1st of October 2023, ruling the matter of Life Esidimeni Inquest, case number I-001 of 2021. Thank you, Judge.
Thank you. Mr. Martin, I think this is your turn on behalf of Dr. Tiehom Selebani.
As it pleases your ladyship. Lady, as I set out yesterday, Mr. Watt Pringle and I have decided that I will take the argument.
Okay.
My lady, I will not take up much of your time this morning. Your ladyship might have noted from the evidence leader's submissions. My lady, I apologize. I see a hand from Mr. Sibara.
Yes, Mr. Sibara?
Sorry, my lady. My apology. Today I won't be on the screen. I'm wearing the Springbok jersey. I apologize, my lady.
I hope
Sorry,
you are
Mr.
not.
Martin.
All right, that's fine, but I'm not going to allow things like this, please. Mr. I think this should only be today. It can't be right
My
that
lady,
you would want to address the court.
It's only today. It's only today.
Yes, but my concern is if you have got issues to raise with the court, then it might be a problem. But in any event,
I apologize, my lady.
All right, Mr. Pitlela.
Morning, my lady. I apologize for interrupting Mr. Martin. Miss Karina Morales asked me to inform the court that she will not be attending because she has a death in the family. Her husband has passed on. I understand that the court had warned the witnesses to be present at all times. Hence, I'm conveying this message.
Okay, thank you. Noted. Is there any other thing that anyone wants to bring to the attention of the court before we start? I take it's a no. All right. Mr. Martin? Mr. Martin, are you there? Am I audible?
Yes, my lady, we can
hear you. You are, my lady.
Yes. Can you please check what is happening on Mr. Martin's side? Or was he kicked off?
My lady, my juniors made contact with him. He's on his way back. He seems to have been kicked out of the hearing.
Okay, thank you, Mr. Hodes.
Thank you, my lady. He's lost signal, so he's trying to...
Okay. Thank you very much.
Thank you.
Yes, Mr. Martin.
My lady, I apologize for that. We seem to have been load-shedded, and with that, the signal went, and it took a while for it to come back on. I apologize. I don't think it'll happen
You may
again.
proceed then.
My lady, Dr. Celebano has filed two sets of heads of argument, a primary set and a responsive set of heads. I'm going to try as far as possible not to refer to their contents except for in just a few discrete areas. The primary sets of heads have dealt with any prospective charge against Dr. Celebano. It's dealt with questions of any act or omission on his part, as well as and your ladyship might have noted that Dr. Celebano agrees with the submissions that have been made by the evidence leaders in most all respects, with the exception of one discrete issue relating to...
he has to, because they favor him, isn't it?
That's quite right, my lady.
Yes, continue.
My lady, I'm not going to address your ladyship on our submissions in relation to Ms. Molefe. We've set it out in the heads of argument, and why we've stated that there was another cause for Ms. Molefe's death, and it related to negligence on the part of the doctors. Ultimately, my lady, I'm going to confine myself to the submissions that have been made by Ms. Forster and Mr. Pino. Ms.
Just
Forster,
before you, I'm sorry to interject. I've
Yes.
read your heads, and just before you move to other points, in relation to the tests, I haven't asked this question yesterday, I think. The argument by Mr. van Bergen that
Yes.
maybe the court can also consider the civil standard of proof in determining the issues before this court, and also reference to UK. I haven't heard any one of you addressing those, but you seem, all of you, to be in agreement with regard to the primary issues in relation to factual and legal causation.
Yes, my lady, from perhaps maybe if I can just take a step back, your ladyship will have noted in our primary heads of argument that we referred your ladyship to the Goniwe case.
Yes,
As
that one.
did,
And I think you are not the only party who's raising that. Yes, correct.
Yes, as did Ms. Hassam, as I understand it, and Mr.
In
Pino.
the sense that
Mr. Pino,
the court should have a look at a less stringent standard.
yes, it's not beyond a reasonable doubt.
Correct. Yes, there we agree.
Yes, I understand what Mr. Late was arguing, and he can tell me if I understand him incorrectly.
Okay.
But I understand that the position that Mr. Late is in is effectively, he says, the facts that you have are objective facts. They're not getting any better than this. When you go to trial at a later stage, there's going to be no more evidence than your ladyship already has before her. This is a very old case. It's a case that is characterized by a distinct absence of evidence, actually. There are only a few post-mortems that were ultimately conducted. So it may well be that the standard under Goniwe is less than that of beyond a reasonable doubt. But your ladyship is to some
acceptable evidence that can be considered at a later stage. That's how.
And I agree with
yes.
Mr. van Bergen on that point. And on that issue as well.
But now, okay, let me cut you short. There we agree. But now, what I want you to address is the issue of the civil standard of proof, and whether I had Mr. Pinar addressing the issue of cases, UK cases, that the court, it's not necessary for the court to go there. But I just wanted to hear you, because I can hear all of you are saying other things other than what Mr. van Berg, he is the one who brought this one. Is it necessary for one to go there?
I don't think it is. With respect, I think that there's been some confusion that's been cast over the proceedings because of some submissions that were made yesterday. I agree with what Mr. Sabara said yesterday. I think he used the phrase, a cancer of confusion, that really came in after your ladyship received some extensive submissions from Mr. Pino on the way your ladyship should make findings under Section 16. And what I would submit to your ladyship is that the court is dealing with a fairly sui generis proceeding here, and your ladyship should be guided by the provisions of the Act itself.
Correct.
And the Act itself tells your ladyship what needs to happen. I disagree entirely with Mr. Pino on the kind of half in, half out onus that he suggested to your ladyship yesterday. The section is very, very clear, section 16. It says, and this is section 16.2, the judicial officer holding an inquest shall, your ladyship must, record a finding. In other words, your ladyship needs to find certain facts or record an absence or an inability to make a finding. As to the identity of the deceased person, the cause or likely cause of death, the date of death. Now, in two of these, we have objective facts that your ladyship will not have to worry about whether or not there's any controversy. Your ladyship doesn't need to worry about the identity of any deceased person. We all agreed on who the individuals are. The date of death, there doesn't seem his death was unnatural. As far as Mr. Stoltz is concerned, my lady, at paragraph 16 of our replying heads, we set out submissions. Perhaps just refer your ladyship to that. It's at Case Lines, page 55750. And I'm just going to take your ladyship through the submissions. We say as follows.
Just bear with
the
me.
alleged basis.
Paragraph 16, eh?
Paragraph 15.
15, okay. Yes, you can proceed.
We say the alleged basis of Dr. Celebano's liability is confusing and contradictory. It's difficult to conceive of how, even if Mr. Stoltz died unnaturally and there's insufficient evidence to support such a contention, his demise related to the decision to terminate the Life Esidimeni contract. After the closure of Siabadinga, he was transferred back to CCRC, which was where he was before he was moved to make space for incoming patients from Life Esidimeni. As summarized by the evidence leaders, Mr. Stoltz's family was satisfied with the treatment that he had received at Siabadinga. It was to CCRC that his family became concerned with his treatment. In other words, Ms. Forster complains that Mr. Stoltz should have stayed at Siabadinga, where he was to make space for incoming Life Esidimeni patients to CCRC, and he should not have been returned to CCRC, where he was before he was moved. Now, I would ask your ladyship to bear in mind that Mr. Stoltz was not at Life Esidimeni. He started at CCRC. But in the end analysis of this confusing set of facts, the decision to terminate the Life Esidimeni contract initially benefited Mr. Stoltz because he was happier at Siabadinga than he was at CCRC. And it was only on his return to CCRC that his family became concerned with his health. And then finally, at paragraph 16, over and above the meandering causal connection between the termination of the LE contract and Mr. Stoltz's passing, according to the evidence leaders, the CCRC clinical files create a picture of diligent observation of the deceased and medical intervention when necessary, and that prima facie the treatment that he received was appropriate. Ladies, my submission is that firstly, there is no evidence before your ladyship to find, even on a prima facie basis, if we were to apply that standard to section 16.2b, that his death was caused by any unnatural means. And secondly, there's no evidence before your ladyship to make a finding that prima facie Dr. really is based on what he says at paragraph 8.5 to 8.7 of his heads of argument. That really seems to be the foundation of the rather cursory allegation that...
Is it 8.5 or 18.5?
I've got 8.5, my lady.
8.5 to 8.7.
Yes, at case lines 55281.
Yes, you may proceed.
Thank you, my lady. Mr. Pienaar makes the following submissions. He says, a further fact of major importance is the fact that the senior officials who had been confronted during the arbitration proceedings with the fact that their conduct had caused and contributed to the death of the mental health care users who had demised were not denied. Significantly, none of the senior officials denied the said conclusions when put to them during the arbitration proceedings by the Deputy Chief Justice, Judge Moseneke. He says at paragraph 8.6, To exacerbate their situation, the fact must not be lost sight of that when such officials presented evidence in this inquest before this Honourable Inquest Court, not one of the said officials contradicted their evidence presented at the arbitration proceedings, nor did they in any manner endeavour to change their evidence at the arbitration proceedings, nor did they in any manner endeavour and credibility of their evidence presented at the arbitration proceedings. And then finally at 8.7, to exacerbate their situation and by electing to act as aforesaid, duly represented by counsel, their conduct amounts to unequivocally admissions of guilt of the facts and in law. They are bound to the admissions they had presented through their conduct, thereby admitting their culpability, be it culpa or dolus, admitting factual and legal causation for the deaths of the 144 mental health care users who had demised. My lady, this is a sweeping and incorrect submission. It's been made clear from the beginning of this inquest proceeding that the arbitration dealt with the issue of damages. And in order to deal with the issue of damages, the department had to politically accept liability. It's the only way upon which the damages could be determined. To suggest that a number of officials went to the arbitration and admitted that they were guilty of criminal offences and that on that basis they should be held liable for the deaths of not the 3 deceased referred to in the evidence leader submissions, or I think it was 10 in section 27s, but 144 mental health care users, it's wrong, my lady, and with respect, it's irresponsible. Not one of these officials can be shown to have made an admission of any guilt of any offence at the arbitration. And I note that Mr. Pienaar does not set out where any of this evidence can be found, so it can be tested and properly challenged. My lady, it's a sweeping statement, and I would urge your ladyship to simply disregard it. But the heads of argument continue, and on the basis now that a number of officials of the Gauteng Department of Health admitted criminal liability at the arbitration, which is untrue, to accusing them of having conducted experiments on 144 healthcare users. My lady, it is startling that these submissions can be made at all. It carries on then at paragraph 14.1, which has now apparently been either withdrawn or adjusted in some way, which is to say, in the premises, it is respectfully submitted that the evidence presented to this Honourable Inquest Court suffices for this Honourable Inquest Court to conclude and find that the officials referred to herein before are, in terms of the provisions of section 16(2)d of the Inquest Act, as amended, prima facie by their conduct or omissions, to act liable for the death of the 144 mental health care users who had demised, and for criminal charges to be considered to be instituted against them, be it for culpable homicide or murder, alternatively in terms of the provisions of international law, either internal in the High Court of South Africa, alternatively in the International Criminal Court at The Hague. Lady, my submission is that there's little that can be said in respect of these heads of argument other than that they are a series of startlingly vague and sweeping submissions that are made without any direct evidence to the causes of death of any of the 141 mental health care users whose deaths were part of the inquest proceedings before your ladyship. They really are just a series of conclusions that are not grounded in fact whatsoever. And I agree with Ms. Ramamela's objections in this regard. It is totally unnecessary for any of these officials to have been put to the expense of answering to these submissions. My lady, aside from that, I would ask your ladyship to have regard to the 2 sets of heads of argument that Dr. Celebano has filed, and unless your ladyship has any specific issues that your ladyship wishes to deal with me, those would be my submissions.
Just bear with me. I think, let me just check that portion where you are talking about the proceedings before the ad hoc tribunal in relation to Mosego. Am I correct? Yes.
Yes.
Just tell me, I'm asking this question again. What is the status of the findings of that tribunal?
Your
before this
ladyship is
court?
not. Your ladyship is not bound by it.
Yes.
Certainly, there would be no question of it sitting as a court, having made a finding that your ladyship would need to abide by, or there's no issue estoppel or anything like that. I would say to your ladyship, rather, where it becomes important is where an allegation is made that your ladyship should simply accept certain things as holding a certain value, or that we shouldn't necessarily be entitled to question certain things. And perhaps if I can put it this way, let's say somebody submits to your ladyship that the arbitration record can be accepted as entirely correct. And your
Yes.
ladyship can take the arbitration record into account. That arbitration record comprises certain things. It comprises the documents that were filed in the arbitration, one of which was the Ombuds report.
Correct.
The
Yes.
Ombuds report was set aside in part by the ad hoc tribunal,
Correct. Yes.
which means that your ladyship needs to take into account not just the Ombuds report, but also all the subsequent events that occurred.
Correct. Yes.
So to the extent that the Ombud made certain findings along the lines that, for example, where the Ombud says that the mere fact that Dr. Manamela signed a license is unlawful because she lacked the authority to do so. A judge and two other assessors have said, not so fast, you're wrong when you say that. She must have the delegated authority to do that. It's insensible that she wouldn't. So to the extent that the Ombud makes a finding, and that finding is incorporated ultimately into the arbitration award, into the arbitration proceedings, into the transcript, your ladyship cannot simply accept at face value that that is correct. And what it does is it highlights the importance that your ladyship must make your ladyship's findings. And that what we cannot do is simply import the findings of Justice Moseneke and accept it as in all respects correct. Your ladyship must deal with the inquest on its own merits. And that's the effective consequence of our submission there.
Okay, thank you.
As it pleases your ladyship.
Just bear with me. All right. Miss Saboko, what is the time now? It's
Lady, we're next on the list.
Are you next before him? Before her?
Yes,
All right. Are you ready to? What is happening with your screen?
My lady, if you can't see me, I'll switch apparatus because I've got others running here just to be absolutely
We're seeing
safe.
some. I don't know what is this. Is it your desk or what? I don't know.
I'm going to switch off this one, my lady.
Okay.
Thank you, my lady. I apologize for that. My lady, if I may, before I even begin my argument, acknowledge firstly Mr. Martin and Ms. Ramamela, who I identify with in their submissions to your ladyship. And I'd like to answer your ladyship's two questions of today. Yes. Our team is of the view, my lady, that in answer to your question relating to the onus, we say that an inquest is a hybrid that doesn't fall squarely within either criminal or civil onuses, and may be defined in our respectful opinion as being a sui generis, inquisitive inquiry to satisfy the court that there is a prima facie credible and acceptable evidence.
Just a second.
At a later stage. Yes,
just a second, Mr. Hodes. Can I find out? Can you hear Mr. Hodes properly?
I can hear
Yes,
him
my
very
lady,
well.
is just a bit fast.
Oh, okay.
Thank you.
I'll repeat what I was saying. I will repeat. I apologize.
Yes, but please
What we say,
don't
my
be too
lady, is that
fast. If one of
Yes,
your
your
colleagues
ladyship,
says
please.
you are fast, then there is a problem. All right, continue.
Thank you, my lady. I'll repeat what I was saying, my lady. In answer to your two questions of today, my lady, what we say is that makes him or her legally liable for the death or deaths of any of the victims. So, my lady, I've adopted that which has been said in most of the heads of argument and tried to combine it, because we agree with Ms. Hassan that it's not proof beyond reasonable doubt, but the end inquiry is whether a criminal trial will be sustainable. And we all know that the evidence in a criminal trial is proof beyond reasonable doubt. So before I begin, my lady, what I want to acknowledge up front is that a lot of what I wished to address your ladyship on has been covered by Mr. Martin. We have the same interest and the same criticism of our colleagues, unfortunately. But I need initially to express my gratitude to the evidence leaders, Mr. Late and Ms. Marriott, because I believe they did a monumental task in summarizing all of the evidence and putting it together. And it seems thereafter, well, at least in our case, I'm prepared to admit, it made our role much easier in that they set out the basis of the law and the facts, and thereafter everybody piggybacked, so to speak, on what they had said. But my lady, the beginning point is what we stated when we began this inquest, my lady, at page 37878. We placed on record by means of an opening statement, my lady, that Ms. Mahlangu was not personally responsible for any of these deaths. She acted on the advice of the medical specialists and doctors who were involved, and that the decision had been taken by the Gauteng Premier, David Makuru, not her, to implement this process. That was the explanation that we gave up front, my lady, as an opening statement. Things have developed since then, and I will address your ladyship further on that. But in our opening statement, my lady, we also attempted to answer your second question, my lady, and this is at page 37878.
Just before you move, what is? Just give me that previous page for the opening statement.
It's the
Where
same page, my lady. Same page.
Yes, page
37878
or 78
from line 11. Yes, my lady.
Just to say, I think I went to the wrong page. I just want to.
I apologize.
I don't want to struggle while I'm alone. It's just
No,
show that certain things. Seven, 878. You may proceed. I think this my case line is very slow here.
My lady, what we also said at that very same page, 37878, is that we as a team are of the view, with respect, that the findings of Justice Moseneki and the Commission are not binding on your ladyship. And whilst you might have regard to in the light of further
I've got a
evidence
problem here. Just a second. I'm sorry to interject you.
No problem, my lady.
37878.
Yes, my lady.
I think in this happening here. Is that at the end of the expert panel report for the health ombuds?
No, my lady, it's at the opening statements at the beginning of the inquest.
Yeah, but maybe this is, I don't know. Here I got, I don't, that's why I thought I got the wrong page. Is it the correct page for all of you?
Well, I don't mind. It shows the expert panel report.
So you're having a problem like myself?
Yes, it's just a blank page, in fact. I can't read anything.
Mr. Late and others?
Place the correct page.
Come again?
My junior is tracing the correct page. I apologize for that, my lady.
All right. In the meantime, you can continue to address the court.
Thank you, my lady. What we said there, my lady, which answers your second question to Mr. Martin, is that we were of the view, with respect, that the findings of Justice Moseneki and the Commission are not binding on your ladyship.
Come
and
again?
whilst you might have regard,
You are of
they're
the
not
view
binding
that
on your ladyship.
they are not
binding on your
binding.
ladyship.
Okay.
Yes. And whilst you might have regard thereto, in the light of further evidence being led in the inquest, everything is open to reassessment by your ladyship. That's what we stated, my lady, and we
Okay.
stand by that, my lady. As you've seen, my lady, the same witnesses have been called and recalled. They've testified, they've confirmed or corrected or supplemented their earlier evidence. And we believe with respect that your ladyship is entitled to, and in fact obliged, to have regard to their more recent testimony relating to these events.
Okay.
Having answered your ladyship's two questions, we wish to record as follows, my lady, that whilst the others have assured your ladyship they're not going to refer to the heads of argument, but in fact did so, we do not intend to refer to our heads of argument at all. We stand by them fully, but we see no purpose in repeating what we've stated already.
Okay.
We record, my lady, that, as Mr. Light said, when you're telling the
Just
truth, if
before
you
you
repeat
proceed,
yourself,
Mr. Sibara, is it no longer fast for you and others?
Decided to record these submissions on the phone
Oh, okay.
because I was not copying it, or then I'm recording it. Thank you, my lady.
I'll
I
put
don't
it to
know what
slow
you-
down, my lady.
Yes, but you can take it from where you are. There's no need for you to repeat. Please
Thank you, my
stop
lady.
him where you feel that he's fast. He's too fast. Continue,
As your
Mr.
ladyship
Willis.
pleases. My lady, what we want to repeat is what Mr. Light said, that when a person's telling the truth, it serves to repeat the truth that remains the same. And the same applies to when they lie. Repeating it is just repeating a lie. So there's no purpose in repeating it. But what we have learned through the experience of this inquest and what transpired here, my lady, is that hindsight is 20/20 vision. Looking back, one can always criticize with the benefit of hindsight, and we will then know which decisions were correct and which were incorrect. But at the time, we need to put ourselves in the position of the person who made the decisions at the time and implemented the decisions at the time. It doesn't serve a purpose, my lady, to look back with the benefit of hindsight and say, well, you should have thought this because this is what happened. We believe that hindsight is 20/20 vision, and that's why we need to reiterate that one can't adopt an armchair speculator's approach. One must put oneself in the position of the people at the time when the decisions were made and implemented. My lady, I pause in my address to record the correct page for the reference that I was referring your ladyship to is page 37922. And I apologize, my lady, for that. It's 37922.
Let me just double check it first.
As your ladyship pleases. It was the opening address, my lady, on the 19th of July, 2021.
Yes, I think this is something. There you are, Mr. Sibara, page 37922. Thank you. You may proceed.
Thank you, my lady. Now, my lady, we want
just for the purpose of the record, I'm going to request that all counsel who address the court make sure that the pages that you refer the court to are the correct pages. Remember, this matter has been going on for quite some time and it's a voluminous record, so that I shouldn't struggle when I am alone. Thank you. You may proceed, counsel.
Well, lady, we want to take a different approach to the previous arguments, and we'd like this to be seen as a breath of fresh air that resonates with everybody, and we'd like to use an illustration by way of example to illustrate that which we intend to argue. What we say, my lady, is this is comparable to a situation where our client found herself in a situation analogous to somebody who has a motor vehicle that they're operating, where they go to their usual dealer over a long period of time, extending over many, many years, and they're told that the dealer is overcharging them. They must go to somebody else. They must use somebody else to service their vehicle. And they're told that the costs that they're incurring don't fit within the budget that's allocated to that purpose. And we say that that's the situation that Ms. Mahlangu found herself in. And I don't want to oversimplify, but it was that type of a decision that she had to make. She was told that there are budgetary constraints. She was told that Life Esidimeni was a step-down facility. It was way beyond budget, the amount expended, and they couldn't get a clean audit. And on top of that, they were not complying with the principle of a step-down facility. So she was told to move. Now, you use, my lady. She then went to another operator or person who could service the car. And that person then said they can do it for cheaper within budget, but that in doing so, they gave her all the assurances that they'd do the same job, if not better. She, not being qualified in that field, not being a mechanic, was guided by them and sent her car to be repaired at this alternative place or dealer. When the car wasn't ready on time, she asked for the car. They said, no, we need more time. She gave them more time. And then she said to them, now I need my car. They released the car to her, but unbeknown to her, the car had no brakes. And then they said, well, you rushed me. I never complained. Well, let me first say, the car was then in a terrible collision and there were fatalities. She's then asked, why did you drive a car with no brakes? And she said, I never knew it had no brakes. But the problem was that the mechanics who knew that they were releasing the car knew that it had this problem and that it could lead to a horrific collision. She didn't have that knowledge, and the collision took place, and now she's in a position where she's called upon to explain. So we have an analogous situation here, where she came into the position as the head of the Gauteng Department of Health, the MEC for Health in Gauteng. There were complaints about the budgetary constraints. A decision was taken. I know there are two different versions on this, my lady. Ms. Creasy and Mr. Makuru say it was her decision. She says it was not. But there can be no doubt, my lady, and we've dealt with this extensively in our heads, that there are different issues or nuances to the decision, but it was taken. And I don't believe that there's a fault in the decision that was taken, but more so in the manner in which it was implemented. And that's the distinction that we need to draw. And it appears that most parties to this inquest have drawn, including Section 27, etc. So let me pause here and say that in this regard, my lady, and the page reference is 54787, the evidence leaders sum this up very, very accurately in our submission, my lady. And this would be the crux of the issue. In their paragraph 6411 under the heading Criminal Responsibility, and they grouped together Ms. Kwadwani Mahlangu and Dr.
Paragraph?
It's paragraph 6.4, my lady. They grouped together Ms. Kwadwani Mahlangu, we see in the meetings, and what transpired in that regard. Okay. We also, my lady, deal extensively with Mr. Pino's heads of argument. And we say there was, as Mr. Martin told you there, to war crime. Mr. Pino adopts the approach that he seems to be a self-appointed evidence leader who forgets that his own client conceded that she did not carry out her duties concerning the auditing and issuing of licenses. And he seems to adopt the approach that if you admit what you did was wrong, then you're credible and must be let off the hook, so to speak, because he doesn't deal with holding his own client responsible as opposed to others. Whereas if you fast in your view and you stand by what you said previously, then he labels you as a liar, and he has the audacity, with respect, my lady, to refer to our client as being a blatant liar who was an untruthful witness. But he seems to have withdrawn most of his submissions that he made in writing and only stood with the remaining remnants of what he said. And this is, my lady, at pages 55279 to 5528279.
279
and the following page to 55280 at paragraph 6.5 of his heads of argument.
This is now Miss Foster.
No, my lady.
Mr. Pienaar, yes. 6.5. Okay, just.
And he hasn't retracted that paragraph, my lady. He seems to have retracted aspects, not that. Not even in relation to the allegation of war crimes, my lady. So now, my lady, your ladyship will be aware, it seems that Mr. Pienaar and Ms. Foster weren't when they addressed you, that certain parties had requests costs orders against them, even cost a bonus proprius. We don't find any support in the Act for a costs order, but we do believe, my lady, with respect, that their conduct as evidenced by their heads of argument is worthy of censure. I don't believe that your ladyship can order costs. I would love your ladyship to be able to do so. And I align myself with my two colleagues who say that they did incur additional costs, as did our client, in order to address these issues, which were then abandoned or withdrawn, in the words of Mr. Pienaar. What we say further, my lady, is that Ms. Mahlangu explained the process of how the department worked and what her roles and responsibilities were as the MEC, and she, in a sense, contextualized that which had happened in relation to this matter. And we say in this regard, my lady, that an important distinction must be drawn between a person accepting responsibility as a political head as opposed to personal criminal responsibility. And we say that most of the parties, by acknowledging that she did so in her capacity as a political head, acknowledged with respect that it wasn't one person's individual decision and responsibility, but more of a collective responsibility. And that's why the Department of Health having decided and having implemented. But we reiterate, my lady, at the cost of repeating ourselves, that she relied on qualified experts within and outside of the Department of Health. They were trained in the specific specialized field, and she relied on them. She is not a qualified doctor, and she did not have the necessary training to make these decisions and to implement them of her own accord. We do not, and I repeat, my lady, we do not blame Mrs. Creasy or Mr. Makura. We explain rather, and that you have a budget and you have to comply with the budget. But we don't say that they are to blame. We say that in this instance. When our client was requested to grant a further extension by Mr. Mosenochi from the 31st of March 2016 to the 30th of June 2016, she did. When she was told to exclude the minors at Baneng, she did so as well, because she wasn't qualified to argue. But there was never a request on anybody's version for the further extension, and nobody ever notified her personally that there was a problem and that might result in fatalities. In this regard, my lady, I sympathize with your ladyship having to decide, and we refer to this as a gargantuan amount of information, and we stand by that. I don't know of a more complicated, with respect, inquest, my lady, of so many parties being involved and so much evidence having been led and so many rulings having been made than the one that your ladyship faces in this instance in our country. We have dealt, my lady, with the issue of the onus, which was what I was going to address you on later, but I've dealt with that because it was raised by your ladyship with Mr. Martin. We say, my lady, that you cannot with respect ignore the evidence of Diane Nochile when she explained that she had been instructed to actively mislead our client at Sia Bedinga. That, my lady, illustrates with respect precisely what occurred here in the implementation of this decision. Whenever our client was told that there was a problem or any issue was brought to her attention, she reacted and dealt with it. But there's not one person that can come forward before your ladyship and say to your ladyship that I told her in no uncertain terms what the problem is and she ignored me. But differently, my lady, there's not one person that can say, I warned her that there's a possibility of death here, and regardless or reckless to that outcome, she proceeded. And it's important in this regard, my lady, to note that it's common cause that Life Esidimeni was always intended to be a step-down facility. Yet, as has been shown to your ladyship, many of the MHCUs were there for extensive periods of time, even decades, which wasn't in accordance with the original plan, which dates back to the contract in 1979, my lady. So when we turn to the heads of argument, my lady, whilst we highlighted certain what we submit of factual inaccuracies in the evidence leaders' heads, and we deal with this, my lady, at their paragraph 73 to 89, and more specifically, they say that Ms. Mkhlangu made the decision to terminate the Life Esidimeni contract. We say that's in dispute. We don't put it stronger than that, my lady. We say it's in dispute. So she took that decision, and that's a make with respect to difference. Because the decision was taken, we say that the flaw was in the implementation of the decision. We say that these tragic and unfortunate deaths were not caused by any act or omission prima facie in via Ms. Mkhlangu. And that's the standard, lady. And we dealt in our supplement, implicated our client, Ms. Mkhlangu. And we, in particular, who filed heads of argument, and states in the heads of argument, it's stated there that she brought the client is incorrect. If one has regard to her cross-examination and her evidence and all of her reports that were highlighted in her cross-examination, my lady, it made it clear that she never ever highlighted any problems to our client. We also, my lady, take issue with section 27 and say that the termination of the Life Esidimeni contract did not cause the deaths of the MHCUs. It was the implementation and the fact that our client had been misled into believing that everything was in order and on track that led to their deaths. In numerous respects, the issue of the false licenses and incorrect licenses is just one aspect which is illustrated clearly before your ladyship. But it's a matter of fact, your worship, that no official ever told her that there was any risk of death relating to the implementation of this project, and she never, in the light of any such warning or risk being made known to her, went ahead as would satisfy the requirement of dolus eventualis, as argued for by Ms. Foster, and to a certain extent by section 27. We say that's not the case, my lady. She was not a qualified doctor, and she was not in a position to make a decision of her own accord. We say, my lady, that there's no evidence to sustain a prosecution of either murder or culpable homicide against our client in a personal capacity. We state that Mr. Kino, in his supplementary heads of arguments, does not concede that our client relied on experts when he labels her a blatant liar and an untruthful witness. We say that this is unsustainable and cannot, with respect, be upheld as a finding of this honorable court, because it's undisputed that she never knew about the court proceedings and what had occurred, and she explained what happened in relation to correspondence received. When dealing with the supplementary heads of argument of Afriforum or Ms. Foster, we say with respect once again, she refers to Mrs. Greasy, which we say is totally uncalled for. But over and above that, she seems to have missed the point that she had been told that she had identified Mr. Mosanochi, and only during her oral argument when she was approached and directly confronted in this regard by our colleague, Ms. Ramamela, that she conceded that it's some type of an error. Now, these errors, my lady, are just unacceptable with respect. And that was the basis, my lady, of the costs order and the de bonus proprius costs order sought against these practitioners. We don't align ourselves and we don't want to play the blame game. We are here only to put forward the case of our client, Ms. Mahlangu. Dr. Manamela never ever, my lady, denied that she had not told Ms. Mahlangu that there was a risk of death. We say, my lady, that with respect, one cannot attribute any liability to our client, even though this is a tragedy of enormous proportions, and even though it's human nature to blame. We say with respect, my lady, that one cannot, if one applies the test of the Act in terms of Section 16, as this court is required to do, hold that she committed any action that resulted in the death of any particular person. We were going to criticize Mr. Pinal further and Ms. Foster for their contentions, and we had labeled them keyboard warriors, but it was clear that they never sustained that which they had said in the heads of argument. So we rest with that which we have stated in both sets of argument on behalf of our client, my lady, and say with respect that you cannot hold our client personally responsible for these deaths in terms of the Inquest Act. Thank you, my lady.
Thank you. There are certain things just before you leave, Mr. Yes.
Yes, my lady.
In your heads, I think this is paragraph 85 on page 54842.
What we're saying here, my lady, if one has regard